Hi folks, and welcome back to Contract Law. This is video 6 in the video series on discharge of contracts. And in video 1, we had a look at the foundations of discharge. In video 2, we looked at performance, then agreement, then we did a 2-part series on frustration. And if that didn't leave you frustrated enough, now we have hopefully the final video or 2 on discharge by termination. So turning to termination. This is a fairly complex area of contract law, so really we'll just be getting started on the basics today. We'll look at terminology and election, and we'll look at termination for breach by way of actual breach and anticipatory breach. So without further ado, let's jump into the basics. The first thing that we need to do when we're talking about termination, particularly in this latter half of the unit, is we need to contrast it very clearly with the concept of rescission. The concept of rescission was covered in the first half of the unit, and it applies to the vitiating factors of mistake, misrepresentation, undue influence, unconscionable conduct, duress, and those kinds of vitiating factors. You will recall from our discussions around rescission that it is a concept that's applied ab initio, that is from the beginning. So what the court does when it grants an order for rescission is it unpicks the contract. I think of it as unravelling a knitted jumper or a piece of thread like I've got on the slide there. It unpicks it so that there's really nothing left between the parties. And a part of all of that process of rescission is the orders for restitutio in integrum. And you'll recall that those orders are designed to give property back, give money back, restore the parties to the position that they had at the beginning of the contract. Very important to get the concept of rescission very clearly distinguished in your mind from the concept of termination. Termination, as you can see, I've got on the other picture there, it cuts a contract off at the point at which it has been terminated. So everything that has happened up to that point stays on foot, like that little half a lolly snake there. All of those good parts there that are left will stay on foot, but everything from the point of termination onwards is extinguished between the parties, is discharged between the parties. They have no further contractual obligations to each other from that point onwards. Now, when you terminate in terms of compensation, you're not going to be looking at orders for restitutio in interim to get you back to the beginning position. You're not going to be looking at damages in tort to get you back to the beginning position that you were in. You're going to be looking at asking a court for damages in contract. And the contractual measure of damages is very different to the tortious measure of damages that will apply if you have rescinded a contract and are awarded damages in tort. Damages in tort get you back to that pre-contract position. Damages in contract are designed to get you to the position as if the contract had been completed. So essentially you're asking the court to give you all of the rest of that lolly snake that has been cut off from the point of termination onwards. So that's why they're sometimes called expectation damages, because the court's trying to give the wronged party what they would have got if they had expected full completion of the contract. So that's termination and rescission, and where they sit in the grand scheme of remedies. Just a bit of a mud map there for you, some terminology so that you can start to filter that away in your brain and get it very clear before we actually talk about remedies in a lot more detail in the remedies video series. So that is termination and rescission. The requirements for termination are that a party has to be ready, willing, and able. Any party in any contract has to be ready to perform their obligations. They have to be happy enough to do so, willing to do so, and they have to be able to do so. That is, they have to be physically, financially, and otherwise able to actually do what they've promised the other party that they'd be able to do. The terminating party, because they are taking a very drastic step, and usually it is a step because of the other party's breach, must not be in breach of an essential term themselves. Okay, it's all right if the terminating party has had some little misdemeanors around the edges, so breach of a non-essential term, breach of a non-promissory term. As long as there's no causal relationship between the terminating party's breach and the other party's default, which has been used as the reason for termination, then you should be able to go ahead and terminate. So two big ones: ready, willing, and able, and no naughty breaches of essential terms. If you've got those two things down pat, then you should be able to terminate after, obviously, considering all of the principles and doctrines that surround the issue of termination. Once your client works out that there are some facts that might allow them to terminate, then you have a choice, don't you, obviously? And here we have the Doctrine of Election. You have two inconsistent avenues that your client could take. Your client could either accept the other party's breach and terminate, which would bring the contract to an end, or your innocent party can affirm the contract. Now, in that circumstance, the contract continues. But remember, that party, that innocent party, isn't left without a remedy. They can still certainly sue for breach of the contract, so they can ask for damages, but they've decided to keep the contract going. The Doctrine of Election requires any choice one way or the other to be communicated very clearly and unequivocally. And it's a fairly important decision to make, because once the decision is made, it's irrevocable. So you can't choose to affirm a contract and then say, oh, it's my mistake, I actually don't want this contract anymore and I will actually terminate for whatever it is that you just did. Similarly, you can't terminate and then go, whoops, sorry, I actually really do want this contract, I'll just affirm the contract now. It's a once-for-all time decision, and there's no going back once you've made it. Sargent and ASL is the High Court case there. The only small exception to that is if you have decided to affirm a contract and then the other party doesn't take the hint and mend their naughty ways. If that's the case and they continue the same kind of breach after you've indicated that you'll affirm and keep going, then for their fresh breaches, you have a fresh right to terminate, and so you may elect to terminate for their continuing breach. Okay, but generally speaking, it's a once and only decision that you'll make when you elect to terminate or affirm. Some examples. Clear instances of elections to terminate are things like in Holland and Wiltshire, where Mr. Wiltshire was selling some land to the Hollands defaulted, and after the Hollands defaulted, Wiltshire sold the land to somebody else. That's going to be a fairly clear message of an election to terminate. After the other party rejects the contract, we'll talk about that in just a moment, that's repudiation. After the other party rejects the contract, if the innocent party fails to perform, that can also be interpreted as an election to terminate. Have a look at Vital and North there. Affirmation, clear instances of affirmation are usually things that can only be attributed to the parties keeping that contract on foot, and the big ticket item here is accepting payments. Classic instance of somebody affirming a contract, keeping it going. You're not going to take the money under the contract if you don't accept that the contract's going to keep ticking over. So that's the Doctrine of Election. Now, the first of the two main bases for terminating a contract is termination for actual breach. And that might be a breach of a condition. So if you look down at the red arrow, you have to ask yourself, would the party have entered the contract without assurance of strict or at least substantial performance of that term? That's the old Associated Newspapers case. If that kind of condition has been breached, it's going to give rise to a common law right to terminate. It might also give rise to a contractual right to terminate. That is, the condition was so important to the parties that they actually expressly state in the contract that breach of that term will allow the non-defaulting party to terminate. So you might have two sources of rights to terminate for any given breach of condition, just purely by virtue of common law principles or by the express terms of the contract itself. So that's breach of condition, or you might have a serious breach of an innominate term. And if you look at the little blue arrow, you need to ask yourself, did the breach deprive the non-defaulting party of substantially the whole benefit of the contract? That's the old Hong Kong first shipping test. Now, if that is the case, the innominate term will be treated as a condition and it will allow the non-defaulting party to terminate. The source of your right to terminate there will simply be your common law right to terminate for serious breach of an innominate term. The breach might arise by way of failure to perform, that is, they refuse or they can't perform, so performance doesn't happen at all, or it might be defective, and we've had a look at partial performance and defective performance in this video series. Either way, there's been an actual breach, and either way, if the term that's been breached satisfies one of those red or blue tests, then you're going to be able to terminate. If the breach fails one of those tests, as I say down the bottom there, with the lady that looks very happy, even if it's only a breach of warranty, you can certainly still sue for damages, so you can get some kind of compensation for what's gone wrong. So that's termination for actual breach. The other main basis for terminating a contract is repudiation. And this is an umbrella term, and it basically means that the party, by way of their words or their conduct, clearly tells the non-defaulting party that they're rejecting the contract. They might do it by stating that they no longer intend to be bound by the contract. They might state that they don't wish to be bound by a fundamental term of the contract. That's the Lorinda and Capalbar Park Shopping Centre case. Or the defaulting party might indicate that they're only going to perform the contract in a way that suits them. That is, in a way substantially inconsistent with their agreed obligations.
You get sent here every day, Craig.
I know.
Why can't you behave?
I don't know.
And that's the Chevron Builders Licensing Board case there. Another form of repudiation is anticipatory breach. Now, as the name suggests, it occurs before the actual time for performance. So there's been no actual breach, but before the time for performance, the party has said, I'm not going to perform. Well, they've done something that clearly indicates they're not going to perform. Now, even though there's been no actual breach, you can still interpret that anticipatory breach as a repudiation of the contract, and it will give rise to a right to terminate the contract. So they're the different forms of repudiation. Repudiation is a very serious matter. It's not lightly found, and often you'll get a series of fairly unacceptable conduct by one party, and it still won't add up to what the court says would be enough of a signal that they're going to repudiate the whole contract. But you will find that there is a tipping point. And in Progressive Mailing House and Tabali, you had the lessee who was rather naughty, failing to pay rent, failed to open on time, obstructed access to the premises, caused damage to the drains, sublet the premises without consent. The question there was, could all of that naughtiness add up to repudiation? Court hummed and hard and finally came down on the side of yes, it did. So it's going to have to be a lot more than just not paying rent on time. It'll be a series of fairly pugnacious conduct that will add up to repudiation of the whole contract. Now, as we just saw in the Progressive Mailing House, a repudiation may be implied from the sum total of conduct, or it could be expressed and very to the point and matter of fact. So in Hoxter and Delatour, we had Delatour engaging Hoxter as a courier, and 3 weeks before poor old Mr. Hoxter was due to start, Delatour wrote and said, sorry, don't need your services. Hoxter sued, and it was found that there had been express repudiation by way of anticipatory breach, obviously, because the start date hadn't even rolled around yet. Nevertheless, because of the repudiation, Hoxter was awarded damages. Implied, a very clear situation here, Lovelock and Franklin. Dell agreed to sell some land to Lovelock if Lovelock paid £140 within 7 years. Before that time had elapsed, and before payment, Dell got rather impatient and sold the land to somebody else. Lovelock sued Dell's executor, who was Franklin. It was held in that case that the subsequent sale was an implied repudiation by anticipatory breach. So instead of being a lot of little things that went wrong, like in Progressive Mailing House, here we had one big thing, selling the house to somebody else. So that is the nature of repudiation that can be expressed or implied. You might also have repudiation by way of inability to perform. Now remember, just before we said that a party has to be ready, willing and able to perform their contractual obligations. If they are unable, they might be ready or willing, they are unable to perform, then that's going to be just as serious as any other form of repudiation. The inability to perform may be communicated expressly by words or acts. So, as in Foreign and White, we had a land sale contract again. There, the vendor was unable to remove an easement before the required date for settlement. So they communicated with the purchaser and said, sorry, look, we won't be able to get this done in time. That was held to be a very clear repudiation of the obligation to settle on time there. Time was of the essence. The inability to perform may also be implied from the surrounding facts. Now, if you're going to try and imply the other party's inability to perform, it's going to have to be quite clear to the court that they wouldn't actually go ahead with the contract. So you're either going to have to show that they were wholly and finally disabled from performing, that's the Sunbird Plaza test, or you're going to have to show that there is at least a substantial incapacity to perform, and that's the Almond Investors slightly lower benchmark there. But that's the issue of inability to perform so far as repudiation goes. Now, repudiation of its own doesn't do anything. The contract will actually continue until the repudiation is accepted and the innocent party elects to terminate for the wrongful repudiation. Okay, so again, you have the Doctrine of Election cropping up here. For anticipatory breach, you don't have to wait until the time for performance. That is when the anticipatory breach would crystallise into an actual breach. You can just accept the anticipatory breach as a repudiation and terminate immediately. Now, if you decide to affirm a contract after it has been repudiated by the other party, you may immediately seek specific performance, and that's the Hashnam and Senap case there. There might be certain allowances that get made because the time for performance hasn't yet rolled around. Performance can certainly continue despite the breach, and that's the White and Carter Council's case there. And the contract certainly remains enforceable, and that's the Avery and Bowden case. So that is a very quick Cook's tour of repudiation and accepting the repudiation and electing to terminate for the other party's repudiation. Now, the big risk here You'll remember before I said that repudiation is certainly never lightly found. Termination itself is a very grave matter, as I said before, and if you've done it wrongly, you've interpreted the other party's conduct wrongly as repudiation, and you have purported to terminate for that other party's wrongful repudiation. And it was all a big mistake. And in fact, they hadn't repudiated. Then what happens is you yourself or your client has wrongfully terminated, which itself is a repudiation of the contract. That's where I call this the dance of termination, really, because in some cases you'll have one party repudiating, the other party saying, I accept that as a repudiation. The other party saying, no, I accept your wrongful termination as a repudiation, and so on and on ad nauseum. So you need to be very careful and very cautious when you are purporting to terminate for the other party's repudiation. Don't get caught out and do it in a manner that's less than acceptable for wrong reasons and wind up yourself being accused of repudiation. So a high stakes game here. And that is about all we really need to say for termination and repudiation. There are a number of other ways that contracts might be discharged or limited by operation of law, and they are the doctrine of merger, or a naughty and unauthorised alteration of a written instrument. Bankruptcy, you'll learn more about that in both tax and company law. Company liquidations, you'll learn about that in company law, and limitation periods. If you don't get going on causes of action in contract, you may well find that your causes of action are limited by the Limitation of Actions Act, 6 years for simple contracts, and contracts under seal, 12 to 20 years, depending on the jurisdiction there. So, ragtag bunch of other ways. You can look at the text to flesh those out further. But therein lies the end of our little excursion into discharge of contracts, death of contracts, if you will, in a more dramatic turn of phrase, discharge, frustration, termination. And as I always say, if you have any lingering queries or questions, please don't hesitate to email me, message me on Teams, or post something on Teams or on Facebook. Or hopefully I'll catch up with you in a tutorial sometime soon. But until then, bye for now, guys.